What is up, everybody? So I'm back with part 5 of Kathleen Zellner's newest motion on behalf of Stephen Avery, which was filed last Friday on January the 12th, 2024. And I'm going to jump in right where I left off. I will link the first 4 parts in the description below in case you want to go check it out for yourself. So we're going to start out with the opportunity element of Denny. In regard to the opportunity element of Denny, the circuit court stated in its opinion that even if the defendant had met the burden with respect to the motive element of the Denny test, he has not met the burden with the respect to the element of the opportunity under the same test. It is undisputed that Bobby Dassey was on the Avery family property when Teresa Halbach was there and before and after she was reported missing. Normally, even proximity to the murder is sufficient to show opportunity. However, the circuit court improperly imposed a burden on Stephen Avery to prove that Bobby Dassey had the skills, contacts, tools, time, and or other means necessary to have committed the crime and staged the scene in order to satisfy the opportunity element of Denny. Then it talks about a case that the circuit court cited, which was State versus Wilson, for its own finding that Stephen Avery has to prove that the potential third party had the skills, contacts, tools, and or time and other means necessary or have committed the crime and staged the scene in the manner alleged. However, in reality, the principle came from the Kansas Court of Appeals that the state cited in its response brief, which was State versus Crinder. Even if the principle from the Kansas case were somehow applied to Wisconsin, the facts of Crinder are completely opposed to those in Stephen Avery's case. In Crinder, the defendant's evidence of a potential third-party perpetrator consisted of alleging a potential motive for the victim's son-in-law to kill her, in that the son-in-law's wife would benefit from the inheritance and that the son-in-law could have had the opportunity to get the defendant's hair from headgear and blood used from bandages to later plant at the crime scene while staying there overnight because he worked as a first aid officer at the defendant's work. The court found that the evidence did not effectively connect the third party to the crime, stating the evidence is nothing more than mere speculation and conjecture and does not connect the third party to the crime, and therefore the district court did not err in excluding it. Rather than considering that this principle came from a Kansas case and not a Wisconsin case, the circuit court imposed a burden on Stephen Avery to demonstrate that Bobby had sufficient knowledge to plant evidence. The facts of the Wilson case are completely in opposite to Stephen Avery's case. In Wilson, multiple eyewitnesses identified the defendant as the shooter. The defense attempted to argue that someone else was the shooter by offering evidence of an alleged potential third-party perpetrator. However, the potential third-party perpetrator was completely unknown because the defense's theory was that a hitman was hired by the man in the car with the victim to kill the victim, and then the hitman shot the victim. The Wilson court found that there was no evidence showing that the man in the car with the victim had the opportunity to hire a hitman in the brief amount of time he was in the car with the victim before he was shot by someone else. The defense failed to present any evidence of contacts, influences, or finances used to hire a hitman or corroborate its hypothetical theory that a potential third-party perpetrator was some unidentified hitman. Thus, the Wilson court case found that Wilson failed to demonstrate that these alleged assassins were anything but purely hypothetical people. Importantly, Wilson is not a case about planning evidence or framing. Wilson specifically stated that this type of theory only requires a showing of access to frame, stating the following: if the defense's theory is that a third party framed the defendant, then the defense might show the opportunity by demonstrating the third party's access to the items supposedly used in the frame-up. However, the circuit court erroneously reasoned that pursuant to Wilson, Stephen Avery must prove that Bobby Dassey had the significant knowledge to recognize the significance of each piece of the forensic evidence used planted by him, let alone establish that he had the skill to plant the evidence in a way that would stand up to scientific scrutiny by professional crime scene analysts. This is not the standard for showing a third party framed the defendant. Evidence that the third party had access to the items used in the frame-up is sufficient to pursue Wilson. Ultimately, the circuit court imposed upon Stephen Avery a standard for satisfying the opportunity element of Denny that has never before been applied in any Wisconsin case. Never before applied in any Wisconsin case. Wild. State versus Vollbrecht is a case which the evidence of connection and motive carried the strength of the opportunity evidence. The trial court granted the defendant a new trial, and the appellate court affirmed, although the evidence of the third party's opportunity only theoretically put the third party in the geographic area of the murder of the victim, and the appellate court focused on the strength of the evidence of motive and direct connection rather than imposing any higher burden to show opportunity, as the circuit court in Stephen Avery's case did. The facts of the case are similar to Stephen Avery's case, where in both cases the defendants were convicted based in a large part completely on circumstantial evidence. In the case, the defendant was convicted of first-degree murder and first-degree sexual assault after a woman who had been shot in the back and was found in a wooded area naked, hanging from a tree by tire chains. Jeez. The defendant had been with the victim the day before she was reported missing. He told police that he was dropped off by her, but detectives spoke to several people who knew the defendant and were in the area when he claimed the victim dropped him off, and none of them saw the defendant in the area. Police interviewed a witness who identified the defendant as the person the witness saw near the area where the victim's body was found on the day she was reported missing. Further, the defendant's hairdresser told police that the defendant talked to her about the murder investigation and told her that I didn't do it, and if I did, I don't remember doing it. A witness who lived near the area where the victim was found testified that he woke up and heard shots around 2:50 a.m. and the sounds of a car dragging, which then stopped. He heard it start up again 20 minutes later. His testimony was used to establish that the victim was murdered before 3:30 a.m. at the time which the defendant estimated he had parted ways with the victim. 20 years after his conviction, the defendant filed a motion for a new trial based on newly discovered evidence of a third-party perpetrator who had been convicted of a similar killing only 6 weeks later. The new evidence stemmed from the post-trial discovery of police reports, including information that the search of a third party's residence uncovered a revolver and books involving rape, chains, and torture, notes about third parties' statements to co-workers about tying up girls, abusing them, and getting rid of them, and statements to inmates that the third party liked to chain and burn women. Jeez, man. The state took issue with the opportunity prong of Denny being satisfied and noting that the third party lived 30 miles away from where the victim was found and also had killed another victim 30 miles away. It argued that the opportunity evidence must be more than just theoretical possibility of the third party committing the crime. However, the appellate court rejected this argument and found the record reflects that the post-convictions court determination as to opportunity was made in the light of evidence presented as motive and direct connection. We agree with the defendant that facts given to other facts and that the significance of the third party's opportunity to commit the crime depends on the alleged motive and direct connection. In Stephen Avery's case, the opportunity element has already been decided previously by the courts. According to Stephen Avery's trial court, Mr. Avery's trial defense counsel already established that Bobby Dassey had the opportunity to commit the murder of Teresa Halbach because he was on the presence of the property at the time Teresa Halbach was there. Moreover, Stephen Avery's new evidence could not present a better case for showing a third party's access. According to evidence of a frame-up, the Thomas Lewinsky evidence greatly strengthens Stephen Avery's evidence that Bobby Dassey had the opportunity to commit Teresa Halbach's murder because it shows that Bobby was in possession of Teresa Halbach's vehicle where her murder likely occurred. He had access to Teresa Halbach's vehicle and all of the evidence used to convict Stephen Avery of her murder. If the defense theory is that a third party framed the defendant, then the defense might show opportunity by demonstrating the third party's access to the items supposedly used in the frame-up. Stephen Avery has not only shown Bobby Dassey's opportunity because of his proximity to the murder, but also because he had access to the items used in the frame-up. The defense theory of a third party's involvement will guide the relevant analysis of opportunity evidence in the Denny case. It is not the circuit court's theory that guides this analysis. Rather than accepting this, the circuit court found that Bobby Dassey needed some kind of expert scientific knowledge to plant the evidence that he had access to in the vehicle. However, there is no scientific knowledge necessary to know that planting someone else's blood in the vehicle of a woman that went missing would be incriminating. Common sense would suffice. The circuit court did not explain what special skills it took to shoot Teresa Halbach in the head that Bobby Dassey lacked. All that was required was to pull the trigger. Bobby was a skilled deer hunter with a .22 rifle. He had obviously pulled many triggers. In terms of planting the evidence with the blood, the only skill that would be required is taking a wet sponge, removing Stephen Avery's blood from the sink and dripping it 1 to 2 millimeters into the RAV4 and applying it to the dashboard with a household item such as a Q-tip. Stephen Avery told law enforcement in his recorded interview that his finger, which had been cut open prior to October 31st, 2005, re-bled on November 3rd, 2005, and dripped blood in his bathroom sink and on the bathroom floor. Stephen Avery told law enforcement and his trial defense counsel as he was leaving his property on November 3rd, 2005 and exiting onto Highway 147, he observed taillights of a vehicle close to his trailer. Stephen Avery told trial defense counsel that he noticed the blood had been removed from his sink when he entered the bathroom in the early morning on November 4th, 2005. The bullet fragment found on Stephen Avery's property simply had to be rubbed in Teresa Halbach's blood on her skin cells, both of which her murderer had access to before her body was burned. The court determined the state did not argue that this specific bullet entered Teresa Halbach's skull or killed her, and there were no bone fragments on the bullet. It is undisputed that there were bullets all over Stephen Avery's property from Mr. Johnson shooting gopher holes with his .22 rifle, as well as Jody firing it. This was the gun that fired the bullet that was found on Stephen Avery's garage floor with Teresa Halbach's DNA on it. No skill was required to plant the electronic devices in Stephen Avery's burn barrel. The fact that there were burn barrels at Dassey's property, 4 in total, one of which contained human bones, shows that the Dasseys, which includes Bobby, were proficient in burning material in the burn barrel. Part of the circuit court's interpretation of Stephen Avery's guilt is based on another factual error. It is its belief that all of Teresa Halbach's bones were found in the Avery burn barrel. They were not. They were found in the Dassey burn barrel. Dr. Eisenberg claimed that when she opened the container of bones from the Dassey burn barrel, she got a waft of flammable liquid or fluid, but did not smell rubber from tires, which the state claimed was the accelerant that Stephen Avery used. The evidence suggests that Teresa Halbach's body was burned in the Dassey burn barrel, then dumped in Avery's fire pit. Common sense suggests that Stephen Avery would not have been planting evidence to incriminate himself. The circuit court erroneously stated that Stephen Avery argued that Bobby planted the key to the victim's RAV4 in Stephen Avery's trailer between November 3rd and November 5th, 2005, and there was no such argument made. Bobby would have had the key when he planted Teresa Halbach's vehicle on November 5th because it was undisputed that the RAV4 was locked when it was discovered. So whoever left the vehicle on the Avery property necessarily had the key and locked the vehicle. Bobby had access to Stephen Avery's unlocked trailer from early Saturday morning, November 5th, until shortly before noon when the vehicle was located and the Avery property was secured by law enforcement. Stephen Avery and his mother left for their cottage around early Saturday morning. According to the circuit court criteria, Stephen Avery was even less qualified to commit the murder than Bobby by way of comparison. In terms of his education, he was less educated than Bobby Dassey. Never having graduated from high school, he was less skilled than Bobby Dassey because he never held a job because of his wrongful conviction, whereas Bobby was employed as a third shift worker in a furniture factory. During all the years Stephen Avery was incarcerated for his wrongful conviction, Bobby Dassey had been honing his skills in stalking, hunting, killing, burning, and dismembering game. After misapplying Wilson to the circuit court erroneously presupposed that the forensic evidence against Stephen Avery stood up to scientific scrutiny in Stephen Avery's trial. Stephen Avery's defense team never presented the required experts to attack the significant evidence. Stephen Avery, in his second post-conviction motion, presented voluminous evidence from numerous experts that the forensic evidence was used to convict Stephen Avery was vulnerable to being discredited if the defense actually presented all of the experts that trial defense counsel failed to present, such as DNA, trace, blood spatter, fire, forensic pathologists, and ballistics experts. The court determined certainly these conclusions tend to support Stephen Avery's general theory that he was framed and that their presentation may have been useful at trial, but concluded that Stephen Avery's experts had failed to show how its introduction at trial could have reasonably led to a different outcome. Now, this court has the direct link between a third-party suspect and the forensic evidence. This court can consider Stephen Avery's forensic expert opinion in light of the identification of a third-party suspect in determining if this evidence could reasonably have led to a different outcome. For example, Stephen Avery's blood spatter expert described the blood pattern distribution in the vehicle with being inconsistent as coming from an active bleeder, as the state claimed. Knowing Bobby had access to Stephen Avery's sink with blood in it and how simple it would be to selectively drip the blood in the vehicle, this court should reconsider the blood spatter expert's affidavit. Stephen Avery's DNA expert described that in controlled experiments he conducted with Stephen Avery holding the key for 12 minutes, there were 10 times less DNA deposited on the key that was presented from Stephen Avery on the vehicle found in Stephen Avery's bedroom. The expert suggested that if the DNA on the key was enhanced, some personal item of Stephen Avery was used for this purpose, such as a toothbrush or a cigarette, but Stephen Avery previously presented an affidavit that he noticed his toothbrush was missing in the law enforcement photos taken from the bathroom in his trailer. In regard to the hood latch swabs, Mr. Avery is not abandoning his theory that the illegally collected groin swabs taken from Stephen Avery were substituted for the hood latch swabs when they were delivered to the Wisconsin Crime Laboratory. However, for the purposes of demonstrating that Bobby had the skill necessary to plant DNA on both the hood latch and Teresa Halbach's key, Stephen Avery asserts that Stephen Avery's toothbrush could have been rubbed on both. Bobby Dassey had access to the trailer where his toothbrush resided prior to disappearing. So this is where I'm going to leave off with part 5. I'll be back soon with part 6, which will likely be the final part of this new motion from Kathleen Zellner on behalf of Stephen Avery. Let me know what you think. Leave some comments below. I hope you're having a good day, and I will see you again soon.